Canada's Constitution provides a human rights framework which grounds all legislation and criminal justice policy in human rights. Restorative justice can meet human rights obligations and satisfy the objectives of sentencing through collaborative, non-retributive process. Join me in conversation with seasoned professionals from the fields of law, medicine, and social work as we explore the common ground between human rights, restorative justice, and the law.
Good to meet you. Nice to meet you. Come on in here.
All right. Where does the law come from, and how is it that any of us get any power to do anything to anybody about anything?
Well, initially, and as the Constitution continues to say, we're a country based on the supremacy of God and the rule of law.
To really be committed to spiritual law, or to law at its ultimate, would mean that we care for absolutely everything that came perfect from the hand of the Creator. So there would be no child left behind, there would be no one hungry. The person who has enough would share with him who doesn't, her who doesn't. The person who has far too much would divest themselves of a good deal of that far too much, in order to ensure that there was equity for at least a few others.
The rule of law is basically that we don't have a dictator or some powerful person who can just decide from one day to the next what to do and can make, you know, it to be illegal to be Larry Moore or you know, do whatever they want. They have to follow certain rules and regulations. On April 17th, 1982, we received from Britain, because we had to repatriate our Constitution, the Canadian Charter of Rights and Freedoms. And the Canadian Charter of Rights and Freedoms became the supreme law of the land. So we got an entrenched Constitution. That meant that the politicians in Parliament can't just change it. It's a constitutional document, and we became a constitutional democracy, so that even the federal parliament has to comply with the Constitution. Section 52 of the Canadian Charter of Rights and Freedoms says, any law, federal, provincial, that is inconsistent with the provisions of the Charter is of no force and effect. In Section 2 are fundamental freedoms, not as Canadian citizens, but as anybody who's present in Canada has freedom of religion, freedom of association, freedom of assembly, these sorts of fundamental freedoms. The very most important right in that charter, in my opinion, is Section 7, which is the one that gives everyone the right to life, liberty, and the security of their person, and the right not to be deprived thereof except in accordance with the principles of fundamental justice.
In our society, what that means is, if you arrest me or charge me with a crime, I'm entitled to know, why are you arresting me? You know, what is it I'm being charged with? I'm entitled to certain things, like a lawyer. I'm entitled to a hearing. I'm entitled to have my say at the hearing, not just to know what you have to say about me, but for me to be able to respond to that. I'm entitled, if you call witnesses against me, to be able to ask them questions and to be able to give my side of the story. I'm entitled at the end of the day, if I am being sentenced for something, to know why, to have reasons for that sentence. All of those things are principles of fundamental justice that don't exist in many societies around the world.
Human rights are those ideas about your safety from abuse. They come about not because you've been good or bad, not because you deserve them or not, but because you're a human being.
Well, an awful lot of people aren't getting their rights. They're not getting the basic needs, much less all that they require.
In 1989, world leaders decided that children needed a special convention, their own human rights articulated. It is the first legally binding international instrument to incorporate a range of rights: civil, cultural, economic, political, and social. And as of September 2010, it was ratified, meaning 193 countries said, we'll bring this into our legislation. It's a framework of 54 articles, but the first one says non-discrimination. That means every child on the planet has these rights. It is not something a government gives, nor is it something a government takes away. It is quite simply a birthright that will care for the best interests of the child, and that they have a right to life, survival, and development. And that when we consider the best interests of the child, we'll wonder about participation, meaning we might ask them themselves what's in their best interest. The principles of the Convention, which are in the Youth Criminal Justice Act, are Articles 2, 3, 6, and 12. There's justice provisions that speak to how we do juvenile justice, or supposed to in Canada. They all call for alternatives to jail, alternatives for custody first, with detention as a last resort. Any children accused of or recognized as having been in conflict of the law will be treated in a manner consistent with the promotion of a child's sense of dignity and worth, which reinforces a child's respect for human rights and fundamental freedoms of others, and which then takes into account a child's age. And the focus is going to be reintegration of the child and helping them have a constructive role in society. And it goes on and says we will look at systemic and complex interventions like restorative justice that look at the whole child and their family and their education and their community. These international documents that Canada has signed and promised and is legally bound to be accountable to all give priority to processes such as restorative justice. If you're doing restorative justice, you are doing human rights.
When my son was 12 years old, he was horsing around here in the living room with his friends, and they're getting kind of rough, and furniture was moving, and I'm in my home office, and I come out to stop the melee that's happening out here because I can't concentrate. And I thought, teaching moment. They're 12 years old. So I said to them, I know you're all friends, and you've all known each other from kindergarten, and this is kind of puppy play. But if you were doing this down in the local public park and people didn't know who you were, they might get alarmed by what they're seeing here. And you're 12 now, so the law kicks in. And you could be arrested by police officers if it was serious enough. It could take you to court, and you could, if it was really serious enough, you could go to jail. So now that you're 12, you better start paying attention to what you're doing because the law kicks in. My son looked at me and he said, well, that's not fair. And I said, well, what's not fair about it? And he said, well, nobody told us what the laws were. How would we even know if we were breaking them? And I thought, well, that's fair enough. And, that's exactly, why Beccaria, a long time ago in the 1700s, wrote this on crimes and punishments, that we need to post what the crimes are and what the penalties are so people will know in advance, because punishments were very capricious a long time ago. So I go into my office and I take my Carswell's Criminal Code of Canada and I put it on the coffee table and I say, and there it was, 1,111 pages thick. That's not including the index, by the way. Tissue paper thin, words that 12-year-old boys for sure aren't going to understand most of. And I said, you better read this cover to cover because Section 19 says ignorance of the law is not an excuse. Well, the boys just laughed at me and walked away. And I thought, who got the lesson here? It was me. I thought, we actually expect this. So there's a lot of problems with this notion of punishment as being a response or a viable response for changing behavior. Durkheim in the late 1800s said punishment works very poorly to change the behavior of the offender. It does very little to help the wounds of the victim. And so we're left with the conclusion that punishment is for everybody else. It's for you, me, and everybody else that wants to see that somebody gets it when they do something wrong.
Both the philosophy of retribution and the philosophy of restoration have a lot in common. They both say that the victim is owed something. They both say that the offender owes something. They both say there ought to be proportionality between the two. What they differ on is the currency that will right that balance. Retributive theory says it's harming someone equal to the harm that they caused, and restorative justice says it's the act of trying to accept responsibility and repair that harm that will right the balance.
The criminal law passed by Parliament that creates offences and creates penalties, and at least since 1996 has set out the purposes and principles of sentencing. And so they appear in Section 718 of the Criminal Code. And they are basically as follows. 1, to denounce unlawful conduct. Well, so a judge, in deciding what purpose or principles in a particular case, looks at that as one of the purposes of sentence. Should I be making a statement here to denounce this type of conduct in order to send a message that everybody sees that we denounce this type of conduct?
Can denunciation happen through a restorative process?
And that's part of restorative justice. I mean, to me, that's very clear that when someone's done something really wrong, it needs to be named as that.
And what would that look like?
In severe violence dialogues, the person normally has to acknowledge it was wrong. It's on the table that this was a wrong, that it shouldn't have happened, that it was a terrible thing. That's sort of the starting point. There are applications of restorative justice where you're dealing with much more minor conflicts where the harm may be both ways, and it's much muddier. But in serious offenses, you have to start with the point that somebody did something terrible and something terrible happened.
To deter the person from committing offenses, and usually within that it's both general deterrence to others and specific deterrence to the individual. Often you can see specific deterrence having worked, often by just arresting somebody. The more questionable thing is this business of general deterrence, this belief that by imposing a penalty on one person that's somehow going to send a message to everybody else. Of course, it depends upon whether everybody else hears that message or gets that message, or because most people think they aren't going to get caught. So there's case law and other things that question the efficacy of the general deterrence principle, but in any event.
Well, I think that's morally offensive in one way, because you're using people as a means to an end. You're using one person to try to correct the behavior of others. So you're using that person as a means to an end instead of treating them as an end in themselves, which is their own human being.
I mean, I think anyone who works in youth custody, you see this influx of, depending on the time of year, how many youth are in an institution. And, you know, when one in a group, much like a gang mentality, if one person commits an offense and, you know, gets convicted, I mean, it becomes this bravado, especially, you know, particularly with the boys, of, you know, how much time they're doing. And in reality, they're in that's their world, that's their community. So when all of your friends are in jail, where do you want to be? You want to be in jail. It's despite the trauma that it inflicts over a period of time of, you know, that revolving door of youth going in and out of the system, it becomes a way of life. So it's certainly not a deterrence in terms of changing behavior.
Well, deterrence is a lot more complex phenomenon than people think. I mean, the research is suggesting that punishment as deterrence works best for people who don't need it, or who need it the least, like me. I'm pretty rational. I think of consequences, you know, and so forth. And so it works for me, but a lot of people don't think in that kind of way. And in fact, there's a lot of research that it's counterproductive, that sometimes it actually causes people to commit more crimes. And we could talk, there's a lot of reasons why that's true. There's also research that says that while deterrence may have a certain, as punishment may have a certain benefit to a point, there's a point where it starts working the other way. And most of the time, our responses aren't that nuanced. I think restorative justice is a very good deterrent, because when you have to face up to someone, when you begin to realize what you've done, when that can happen, it's actually a much better deterrent than the threat of punishment over your head.
The third one is to separate people from society where necessary. And so that's imprisonment. You know, it used to be that we used to chop off people's hands and things like that many, many years ago. And imprisonment was brought in as essentially a remedial type of provision, where we would be nicer to people instead of killing them and chopping off their hands. We would simply contain them. Well, we now know from years of experience that containing them for long periods of time or under certain circumstances isn't a very wise thing to do either, and can often make things worse instead of better.
I mean, of course we want to lock up people for restraint, dangerous people whose actions are predatory, and we all know who the cast of characters are that we would include in that. That's what incarceration's for, and historically, incarceration was used for restraint, not for punishment in any event.
Is there room for separation of offenders in restorative justice? Is there room for that to be part of a restorative process, that you need to take a time out for a while?
Oh yeah, I think so. I've worked with so many people who've offended, who are in prison, who have told me they needed this time out. Now we do it, at least in the U.S., we do it in very unrestorative conditions that are traumatizing. Really, they re-traumatize people, and I think trauma is part of what causes people to commit violence and wrongdoing in many cases. But if we could only use that as a scarce resource, if we could limit the time we do it, and if we could make those conditions as restorative as possible, that is, respectful to the person, helping them think and take into account the harm that they've done, giving them input into their process and so forth, yeah, there's definitely I just can't imagine a time when we wouldn't need some way to incapacitate people for a while.
The next one is to assist in the rehabilitation of offenders. That seems like a no-brainer to most people in the system, that we don't want to simply warehouse the person in the prison. We want to do something with them while they're there, so that when they get out, they won't come back. Some people pay a lot of attention to that, and others don't.
You know this from prison, that most offenders who are in prison have been victimized themselves. And even when they haven't, they are often acting out of a sense of victimization. There's a psychologist, James Gilligan, who used to be head psychiatrist or psychologist for the the Massachusetts prison system. He's written a book called Violence, Reflections on a National Epidemic. He argues that all violence is an effort to do justice or undo injustice. All violence is an effort to do justice or undo injustice. Whether you're talking about terrorism or whatever you're talking about. And if that's true, if it's true that people who've committed acts of violence have been victims or believe they've been victims, then that's often a place you have to start. You have to help people think about the victimization they have experienced, evaluate it, work through the trauma that they may have experienced, and then that often is a springboard to start thinking about what they might have done to other people.
In our serious crime program, we're always dealing with people who have been convicted or have taken responsibility and pled guilty. So that part's all done. The judgment's done. And yes, I guess we could continue to think about, prisoners and victims and people with those kinds of categories or those kinds of labels. But almost inevitably, when we get really, really useful healing outcomes, people have been humanized to each other, those categories have dropped away, those labels have dropped away, and they're seeing each other in really, really human ways, and empathy starts to grow. And when empathy starts to grow, that's the thing you're looking for. That's the magic ingredient that will keep that individual from ever going out and violating another person in the same way. He's got victim empathy now in his head and heart and his guts and the marrow of his bones, because he saw the consequences of his criminality or the consequences of his behavior in the life of another person, and it moves him. Unless he's so badly damaged that he can't be moved by it. And those people are really very, very few and far between. Quite frankly, we've seen some people who were pretty much written off as psychopaths who got there and then were reassessed, and people could not understand how it could possibly be that their assessments had shifted, because these things aren't supposed to change. Well, we've seen them change.
Well, one of the encouraging things is the way neuroscience is affirming the relational nature of our brain. I mean, they're saying that the human brain is wired to connect with other people. It's designed to connect with other people. A child, you know, when they grow up and they're very infant, very small, they look at each other, they try to see you, they're trying to connect with you. And they're saying that a normal development, your neural pathways are formed in healthy ways and so forth. But if you're abandoned, if you're abused, don't bond with your parents and so forth, those neural pathways can get distorted. And I saw one neuroscientist who was watching restorative conferences, and he said, you know why it works? He said, because our brains are designed to connect with other people. And if you can make that happen, nothing reprograms the human brain better and faster than an experience of empathy.
In 1996, we added, to provide reparations for harm done to victims or to the community, and to promote a sense of responsibility in offenders and acknowledgement of the harm done to victims in the community. The real focus coming out of those two provisions leads us into the restorative justice aspects of what a court can do, so that the court isn't solely limited, as it used to be, to retributive justice, imposing a certain amount of pain and discomfort in order to think that the person will behave, but to look at what happened to the victim, what happened to the community, why the offender committed the offense, and focus on reparations to the victim, trying to put things back or put things right, trying to restore the imbalance that's been created by the crime. Encourage a sense of responsibility in the offender, so the offender takes responsibility or recognizes what he or she may have done and is prepared to participate in that process of trying to make things right.
So much of what we're doing or attempting to do in our facilitated dialogue processes give victims precisely what they need. And they say to us again and again, and they say to the evaluators, this is what I needed. This is healing for me. This does justice for me. One of the things that victims need is an opportunity to tell their stories in a narrative fashion and in a setting of their own choice, rather than, be subject to a public humiliation or a challenge to their credibility. Oftentimes victims they need validation, they need vindication, they need truth-telling, they need answers to questions that have never been answered. We've seen situations where people have waited 7 or 8 or 9 years just to be able to ask questions of the person responsible for the harms that were committed against them, and watched their view of what actually happened just filled out and transformed in many, many ways by virtue of what they're hearing. And not because somebody's blowing smoke and feeding them another line, but because they're closer to the truth of what happened and they know it, they acknowledge it, it makes sense to them.
A court that is charged with the responsibility of determining what a fit sentence has to take all these things into account, including particularly the gravity of the offense, the nature of the offense, the seriousness of the offense, and the degree of responsibility of the offender, remembering that some offenders are the principals, some are just parties, some are only partly involved, these sorts of things. But the court has to look at the offense and the offender and try to come up with a fit sentence. That's the overall general framework. The code goes on to provide for other principles, so that it requires the court to take into account aggravating and mitigating circumstances depending upon whether they exist in the particular situation.
I mean, all of us when we're emotionally overwhelmed, make very poor choices and experience very little freedom in the face of overwhelming emotion. We rather are dictated to by our lower brain centers, and the cortex, the thinking part, gets quite overwhelmed by a tornado of emotions that just sweep us away. Now, this is especially true of people who had a very hard time early in life and who've led a very stressful existence.
The person's underlying reasons for engaging in a crime are aggravating or mitigating factors. If your underlying reason for being engaged in criminal activity is because you're homeless and you're engaging in criminal activity to survive, that is a very important factor that I think a judge has an obligation to consider when they're sentencing a person. If your underlying motivation is uncontrollable rage and wanting revenge, that's a different factor, but one that needs to be considered. If your underlying motivation is substance addiction that has driven you to the point where you don't have any moral boundaries anymore, where you don't have any sense of right or wrong, you're simply in a tunnel vision driven by the drug, driven by the addiction, then I think that's an important factor that the judge has to consider. Because you cannot come up with an appropriate sentence if you don't know what the reasons for the crime were in the first place.
In the context of a legal system which repeatedly brings addicted people in front of the courts, in fact, much of court activity and criminal justice activity is related to drug use or drug crimes in one way or another. And given that the people thus brought in front of the seats of justice are invariably people who were traumatized in childhood, it's a very heartening development to see the ethic of restoration rather than isolation being promoted within the justice system. I mean, the justice system is really all about isolating people, punitively isolating them. And restorative justice says, how can we restore you to the community?
It requires them to try and ensure that sentences for similar offenses and similar offenders are similar, so that there's no disparity of sentence, so that they try to have some equity in terms of the types of sentences imposed. Consecutive sentences are not to be unduly long and harsh.
I had a conversation a few years ago with a man who had done 30 years at that time, and he had done quite a number of years actually in solitary confinement, which is punishment within a punitive institution. And I said to him, what do you think? This person's name was Andrew. I said, what do you think? Did punishment work? Like, did it change your behavior and all those things? And he started laughing and he said, Liz, if punishment worked, I'd be Saint Andrew.
And two other very important principles that they brought in, one being that an offender should not be deprived of liberty if less restrictive sanctions may be appropriate in the circumstances, and all available sanctions other than imprisonment that are reasonable in the circumstances should be considered for all offenders, with particular attention in the circumstances of Aboriginal offenders. So there, Parliament said, look, and these provisions arose out of the 1983 Sentencing Commission report to Parliament, where the message was, look, we incarcerate far too many people, and it isn't making things better necessarily. And so there was a call for, to try and decarcerate, and particularly Aboriginal offenders, because they were disproportionately represented, given they're a small percentage of the population and yet an overly disproportionate number of them in prison. Ultimately, the Supreme Court of Canada decided the case of Gluedo, in which they reinforced that and said this isn't just a codification of the past law, this is intended to be a remedial section where we start doing that now, trying to use imprisonment less, and particularly in terms of Aboriginal offenders.
Gluedo is not a sentencing discount case. Okay, Gluedo is not a case where you say, well, Your Honor, you would get this guy would get 6 months, but look at him. He's an Indian. Knock 3 off. Okay. I mean, that's not what Gluedo's about. Gluedo's not a sentencing discount case. What Gluedo is about is starting from the premise that we know that jail doesn't work. It doesn't work for anybody. And the court's very clear. The court spends a lot of time in Gluedo talking about Canada as a country that jails too many of everybody. When you read 718(2)E, it's not an Aboriginal sentencing section. People often call Gluedo the Aboriginal sentencing section, and it's not. It's about how everybody should be sentenced. But it says, with particular attention to the circumstances of Aboriginal people. Why are those words there? And the court said because the circumstances of Aboriginal people are, in fact, unique. First of all, there's what the court calls the systemic factors, which play a part in bringing the specific offender before the courts. And the second is the types of sentencing approaches that might be appropriate to the offender because he or she is Aboriginal.
What a Gluedo report looks at, it goes back generally 5 to 7 generations, and it looks at the impact of colonization of the nation, removal from their territories, economy, all of that kind of stuff. Again, the impact on the nation, the community, the family, and on that individual. It looks at all of their circumstances as it flows into that individual. It then goes to the community again and flows back again through that progression to look at what supports are available for this person, how they feel about that person coming back to the community, how they feel about the person's offense and how it's impacted them, not just the offender, his family, the houses, the nation's reputation as a whole. All of that is encompassed within a Gluedo report and placed before the court. We also want to look beyond to look at what problems that the person may have that we can actually provide services for. And we look at that from a restorative perspective. We look at it from a distinctly Aboriginal perspective and incorporate the practice of the healing and the traditional practices of that individual so that they're able to move forward in their life, to become whole, not just be a human, but become a human being.
Every offender has the right to choose the counsel that can best represent them, to develop their own basis of defending themselves or presenting their case before the court. If you commit an offense, you can go to your community and say, I'm going to take accountability for this and I need your help to make sure that what I do meets all the expectations that you have, and I don't want to continue to do this anymore. I need help. I know if I go to court, the lawyer will do all the talking, that the judge will come down with these principles of sentencing and bang, 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 and it won't fit. Nobody is going to feel in the community as if it's a just or proper sentence. So what you do is you can go to the community and say, okay, let's sit in a circle, in a mediation or whatever you want me to do in the community, and let's see if we can work this out among ourselves about what you think. And whatever you think that we worked out together, let's go and give that to the court. I've never met a judge that would ever say, oh, well, no, you guys don't know anything about what you're doing. I know about all the sentencing principles. Thank you very much for your help. Awfully good to see you're interested in trying to help people. Boom, here's the sentence. The worst he's going to do is to say, well, how does this sentence really deal with denunciation? Okay? He actually entered into a dialogue in the courtroom with the program or the plan that they've come up with. You know, if he's smart, he'll say, well, it's really good that young Larry has now gone and got this counseling, and he's come into the treatment program with flying colors, and he's paid restitution, he's done that, that's really good. But now what about, real accountability? And then enter in a dialogue about whether the community thinks, spending time in jail is going to be, a way to gain accountability or not.
Diversion means that you're steered away from the criminal justice system. So basically, diversion has to happen at the front end. And absolutely, there's room for the community to be engaged at the front end. There's room for the community to be engaged all the way through the process. Diversion is one option. And I think it's a good option, and I think it's an option that's seriously underutilized. Once it gets to the court, we can't divert it away. But what we can do is say there are options for looking at whether, if the person were doing well, might Crown Counsel decide that they didn't want to go ahead with charges. So at some points, a charge is laid, a person is brought before the court, and Crown says, yes, we are prosecuting this matter, we're carrying on, but we're willing to adjourn the case over. In other words, not go ahead right now with a trial or not go ahead with a sentencing if the person wanted to acknowledge guilt, but say, let's just wait a period of time. And during that period of time, give the individual and the community the opportunity to do something, to show something, to show some healing, to show some progress. When that occurs, the court's very happy to stand back and say, absolutely, if you think that there's a way that this could be dealt with effectively and appropriately for everybody without going ahead with a trial or without going ahead with a criminal prosecution, by all means.
Nobody's going to heal unless they themselves, at some point, come to the possibility of healing and make a decision in his favor. And they had to come to that. Now, the addict who was traumatized and has never fully dealt, has never been fully helped to deal with the effects of that trauma, is very much constrained by a worldview that leaves him isolated, that leaves him looking for soothing to the outside, that leaves him outside the law, that leaves him with very low self-esteem and a very poor sense of agency, a very poor sense of autonomy. Now, victory in the case of the person heavily caught up in addictions is actually some human contact, some sense of validation for their humanity despite their drug use. That no matter what they've done, what they've committed, or what they've omitted in their lives, they're still worthwhile human beings. They will only get that sense from other people. So the more we can support people, the more autonomy people will actually have to make the right choices.
I think that we have an obligation, those of us who work in the criminal justice system, to ensure that the sentences that are imposed are reasonable, that they're fair, and that individuals understand what's being expected of them and can comply with those conditions. For instance, it's my personal opinion that there is no point in putting a condition on a sentence that says you will not consume alcohol for somebody who has been an alcoholic for 30 years. So we say, well, what is the criminal activity? The criminal activity is when your behavior then impacts somebody else. So if you agree that you're going to stay in your home if you've had too much to drink, or if you're using drugs, or any of those things that can cause harm to other people, then that's the condition that should be part of the sentence. You won't be drunk in public. Not that you'll never drink, but that you won't be drunk in public. Or whatever is necessary in order to protect you and to protect society from you, but doesn't go beyond that.
Corrections and Conditional Release Act, or the CCRA, sets out the purpose of corrections. It's a short statement. It says the purpose of the federal correctional system is to contribute to the maintenance of a just, peaceful, and safe society by carrying out sentences imposed by courts through the safe and humane custody and supervision of offenders, and assisting the rehabilitation of offenders and their reintegration into community as law-abiding citizens through the provision of programs in penitentiaries and in the community. That's it. Other than maintain safe and humane institutions, its only purpose is reintegration. Now, retention of rights is clearly understood legal principle that's in the Act and has been ruled on repeatedly by the Supreme Court. And it basically says that you retain the rights of a citizen when you go to jail, except for those that are necessarily removed by virtue of your imprisonment. There are no such things as prisoners' rights. All there are is your rights that you retain if you go to prison. There's not two groups, one at the expense of the other. If prisoners have rights, they're at your expense. No, these are the rights you have, even if you go to jail, that limits the degree to which government can hurt you.
Section 84 refers to the conditional release of Aboriginal offenders who wish to come back to a community, an Aboriginal community. It does not necessarily need to be their home community. In many cases, it can be an urban Aboriginal community. What they do is, under Section 84, is they work with the institutional elder and with their institutional parole officer and the team that is there to put together a release plan to be able to adequately address their risk factors. That letter is then sent to a Section 84 committee. The Section 84 committee is primarily a representative group from the Aboriginal community in which they would like to come back to. That normally includes your chief, your elders, service providers perhaps. Oftentimes it also includes victims and their representation. They receive the letter, they review the letter in the context of whether they are able, willing to be able to support that Aboriginal applicant to come back to the community. And if they approve of that, then they work with the outside parole officer, the community-based parole officer, in being able to facilitate and reintegrate that Aboriginal individual back into the community.
All empirical data suggests that by far the informal social networks in any community are far better at preventing crime, they're far better at rehabilitating offenders, they're far better at reconnecting victims back to their families and their community and the way of life they had before they were victims.
It's a false assumption in our society that people are discrete individuals, and the reality is that from the biological point of view, our brains are very much intertwined with the brains of all the people that we interact with. And that's easy to demonstrate because all I have to do is to change my facial expression and your brain physiology would change in an instant. If I go from hostile to friendly or the other way, your biology will alter in a moment. And that is what has been called interpersonal neurobiology, which is to say that the nervous system, including the brain activity of a human being, is for a lifetime heavily influenced by their social and psychological interactions with other people. Now for children, this is absolute. Infants have absolutely no capacity in any way to be autonomous emotionally from their parents. This is also true for adults to greater and lesser degrees, so that the healing in the one is very much promoted by compassion in another.
To me, restorative justice has to go that extra step. What is it that it's going to take in order to truly heal? To heal the individual and heal the community. And sometimes that's a lot bigger than just talking about sentencing for that crime. Sometimes it's much bigger in the sense of looking at the community and saying, what's it going to take to help this person or others in the same situation so that they don't offend in the future? Maybe what it's going to take is providing housing. Maybe what it's going to take is providing counseling and treatment for anger management, for substance abuse, for psychiatric treatment. Maybe they've got serious health issues. Maybe they've lost custody of their children. So it requires looking at the much bigger picture and saying, what's it going to take to heal?
I don't think there's a better system in the world that can determine the question of guilt or innocence. But 90% of the cases that come through our system, they put up their hand and say, I want to plead guilty. Most of those cases, not all of them, are better served either in that second combined process or totally by the community. And this is not kind of pie in the sky dreaming. We've got lots of examples where communities have taken the initiative and demonstrated in very serious crimes that their capacity to meet all of those sentencing principles we talk about in the criminal justice system, but rarely give practical demonstration of how we achieve those things, they can achieve those things much better.
It's going to be the retributive justice system unless we intervene or somebody intervenes to say, hey, let's do restorative justice here. Now, it might come out of the person's pled guilty, a pre-sentence report was ordered, and it's in the pre-sentence report where the probation officers talked to the group and others and has said, hey, this is what we should do here. But hopefully it can arise long before that, and so that's why you'd be really dependent upon the police being able to identify an appropriate situation, Crown Counsel and Defense Counsel being able to identify appropriate situation, and maybe developing policy around it.
As you can see, there are opportunities and obligations to consider restorative justice at each stage of the criminal justice process. But that's not enough. It's empathy and compassion that create safe communities. It's up to each and every one of us to stand up for our Constitution, the rule of law, and our inalienable human rights.
Heard that you passed when I was on a mountain, so I sent a prayer with the eagle in the tree. The wind, it blew through the sagebrush and cedar, and I felt the honor of knowing you. Left your mark with love in the hard places, and you taught us all how to lead a march through the bars and the walls that only separate us, and we were brought together